Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 14-1290, Troy Chemical Corporation Petitioner versus Environmental Protection Agency. Mr. Goldberg for the petitioner, Ms. Tan for the respondent.
Good morning, counsel. We'll hear from Mr. Goldberg on behalf of Troy Chemical Petitioner.
Good morning, Your Honor. Thank you very much. It's great to be able to see everyone. This is an appeal from the inclusion on the national priorities list of the Pearsons Creek site in Newark, New Jersey. EPA listed that site based on two factors. First, an asserted threat to 0.15 miles of wetland frontage along Pearsons Creek. And second, an asserted threat to the human food chain based upon fishing observed at a pier in Brooklyn, 13 miles away from the presumed point of release across Newark Bay and New York Harbor. It's important to recognize that EPA doesn't dispute. For this site to qualify to be listed, both factors must be scored in the way that EPA scored them. If either of these two factors fails scrutiny, the listing must be vacated. On the rulemaking record, neither factor justifies the score that EPA gave it under the hazard ranking system. And that's what I will explain this morning. Turning first to the wetlands issue. The principal issue before the court is a straightforward question of administrative procedure. Did EPA provide adequate information at the proposal stage for Troy and others to meaningfully comment? As our brief points out,
suppose we agree with you that the disclosure was inadequate. Don't you still have to show prejudice, which is to say some possibility that greater disclosure might have impacted the bottom line?
Yes, Your Honor, and I have no doubt that we can make that showing.
What would you have done differently? You knew exactly where the wetland was. The only thing you didn't know was the precise location of the soil bores, and you didn't have the pictures. So let's assume you had both those things and we're still in the rulemaking and you're formulating your comments. What would you do differently to make your case that this is not a 0.1 mile wetland?
First, Your Honor, we would have looked at the way in which EPA viewed the New Jersey determination that there is no wetland along the frontage of Pearsons Creek. That is both mischaracterized and inadequately explained in the documents that EPA presented. Second, with the additional information provided in the 90 pages of support that EPA provided with the final rule, but not at the proposal, we would have been able to, first of all, verify whether each of the 18 flag locations and each of the soil borings, in fact, one, had wetlands vegetation, and two, that the frontage is continuous. It's really important to recognize that in this situation, yes?
Well, you have, I mean, you now have the photos. Let's just talk about those. You've seen them. Is there anything in the photos that would strengthen your case that this is not a contiguous wetland over that 1/10 of a mile?
No, I don't believe there's anything in the photos, but, Your Honor, you know, because this record has been closed, we haven't gone to consult our experts about what's in those photos. And most importantly, the EPA needs to demonstrate that there's at least 0.1 mile of wetlands frontage. There's plenty of evidence in this updated record indicating the creek is filled with debris, the flow is impeded, there's been industrialization and disturbed soils. We didn't have any of that back in the time of the proposal. And in fact, we might, given this record, have commissioned our own wetlands experts to go verify EPA's finding. That we could do based on the supplemental record. We couldn't do that based on the fuzzy pink line on the map that EPA provided at the time of the proposal.
But wouldn't you have had more incentive to seek to do your own study and to seek to gain access to the property at issue previously on the record that you had, which is less than on a record that has more?
You know, Your Honor, I think that in this setting, what EPA is trying to do is reverse the burdens in the rulemaking. It's EPA's burden to move forward. We, in fact, went to EPA and said, hey, is there more information? And we were told, no, there isn't. And so we had to assume that the complete record that EPA relied upon was what was in the rulemaking.
When you say that they said no, there isn't, where is that in the record that they that representation?
On page 77 of the Joint Appendix, footnote 3 to our comments to EPA during the in response to the proposal. It's also mentioned in our briefs here. You know, it's EPA's burden to move forward and to provide adequate evidence to support its proposal. And what we said in our comments was there's not enough information to delineate the wetlands provided.
Why doesn't the guidebook, put aside the procedural error, just in terms of whether their determination is supported by the record, why isn't the guidebook sufficient support? They have 9 soil borers. They examine all of them. They're experts on the scene. They explain what they see, and they show 3 positives, which cover the most of the segments at issue, and they explain that the negatives are up the slope from the wetland, which seems to suggest they're coming back negative, not because the vegetation is changing every hundredth of a mile, but because those bores are too far up the hill. I mean, wouldn't we say that's good enough if we were just reviewing the adequacy of the bottom line judgment?
Under the circumstances, Your Honor, I don't believe that is adequate, because what we're looking at is a wetland that barely exceeds the 0.1 minimum distance. Having 3 borings, EPA itself makes clear it's not adequate. They rely on 18 flag locations, but the flag locations, the record at the final rule makes clear, only look at vegetation, not the 3 characteristics that are required in New Jersey: hydrology, geology, or soils, and vegetation. And so it requires the 18 flags as well as the borings, and we have no idea where the flags are, or if the vegetation at those flags, or the soils, or the hydrology meet the requirements in the guidance. And so,
is there any reason to think that vegetation would shift? We're talking about 100, 200 feet on the margin here. I'm not a scientist, but just intuitively you would think that you're not likely to see huge variances go 1 football field down the river, the creek.
With deference, Your Honor, I think that's a question that our experts should have an opportunity to respond to. They should have an opportunity to look, especially in what EPA recognizes and Troy recognizes is an urbanized area where there's a lot of disturbance along the creek, where there's debris and there's all kinds of industrial activity, and a finding by the state that there is no wetland.
Well, the finding has expired, right, by its own terms.
Well, the finding expired, right? The finding would have allowed construction without violating the Clean Water Act. In other words, without being considered to be filling wetlands up to 10 months before EPA's field work. I mean, in theory, it's expired, as EPA points out in his brief, but that's not, you know, if Judge Katsas's question, how quickly will things change? Over 10 months, the idea that, well, yesterday, 10 months ago, there wasn't a wetland, and today there is a jurisdictional wetland, to me is a very difficult leap for...
But how can you rest an argument on a determination that has no legal validity at the time of the comment, at the time of EPA's posting?
We're not suggesting that it's about the legal validity, Judge Wilkins. We are suggesting that the observations by New Jersey, the recognized expert on wetlands in that area, should be addressed by EPA. We're EPA to, you know, have said, well, we've looked at this and, you know, that New Jersey has missed something. Maybe things have changed over time, but what the record says is, we don't have to worry about that because it says there's an open channel.
I mean, it seems to me that if New Jersey had issued a letter that said that this is a wetland and EPA relied on it, you would be here arguing that it has no legal relevance at all because it had expired. And I would think that that would be a pretty good argument. So I'm just trying to get to the nub of the issue here, which is that I don't see it would be reasonable for an agency to ignore that letter under the circumstances, wouldn't it?
Well, again, Your Honor, the NPL listing process, as this court has recognized, involves the application of the hazard ranking system to particular facts. The state of New Jersey made a finding about facts. That finding, you know, may have expired by the time of EPA's field work, but the observations remain valid. And therefore, there is an obligation on the part of EPA to consider the factual predicate that formed the basis for the New Jersey determination.
Mr. Goldberg, I'm not clear about what prevented you or your experts from taking soil samples or core samples or examining the vegetation or noticing that there was a great deal of debris that had accumulated over the years in the creek. What prevented you from, your experts, from making that case?
So we would have had to obtain access, but that may have been doable. I can't say that we were absolutely 100% prevented from...
Is the creek a navigable waterway?
Given the Clean Water Act definition, it probably is, as a practical matter.
Who owns the creek bed?
I don't know. I mean, below Troy, you know, when it crossed Troy's property and it was still a creek, there was an easement in favor of the city of Newark.
The reason I'm asking that is because if it is a navigable waterway, and I assume it's a tidal creek, you can't, the state and private property owners could not prevent your experts from traveling down that creek on a boat and getting out into the mud and taking soil samples.
Well, you know, Your Honor, the record is pretty clear that the only way to get access is through the property south of Troy, through 429 Delancey. That's why EPA's contractors had to return to the site with EPA representatives to use EPA's authority to get access. I'm not saying it's impossible. As to why we didn't, again, this is a matter of the rulemaking process and EPA cutting square corners with its rulemaking. It was EPA's burden in the first instance to do more than paint a line on a map and say, now you go prove we're wrong, fellas. And, you know, that's the scenario that I think, Judge Randolph, you're spinning out here, that we may, you know, once EPA says this might be a wetland, then it becomes the burden of the responding parties to prove that it's not. Again, this is a notice and comment rulemaking. EPA needed to provide adequate information in its proposal to support the position that it wanted to take. and to allow interested parties to comment. And that's our position. And so we didn't seek access at the time, although now I can assure you that if the court vacates the decision and EPA decides it wants to continue to list the site, and it decides it wants to continue to list the site based upon wetland, we'll have people in waders or a boat going to verify whatever the current state of that wetland or the creek banks are, and to determine whether or not it is in fact a wetland.
Given your time is about expired, do you want to say anything briefly about your other issues?
Yes, Your Honor. The other issue raises a separate administrative law question, but one that's no less serious, and that is where there's record evidence contrary to the assumptions in the hazard ranking system, EPA is obligated to consider that evidence. In this case, Troy presented evidence in the record, including all kinds of technical documentation, indicating that it is implausible for contamination from Pearsons Creek to be a factor at a fishery 13 miles away on the American Veterans Memorial Pier in Brooklyn. EPA never responded.
Mr. Goldberg, may I interrupt you there? In your reply brief, you seem to indicate that you were challenging the validity of that regulation. Is
Your Honor,
correct?
The way
Regulation, the 15-mile limit.
there is, we see there being a hierarchy of ways the court could decide this case. One is to say that the EPA's interpretation of its regulation is arbitrary and capricious because it's contrary to the purpose of the HRS, it's contrary to the preamble of the HRS, and because this court, in multiple decisions, including several cited in our briefs, have said that assumptions must yield where there is record evidence to the contrary. In the event that the court finds that EPA is correct, as it argues on page 25 of its brief, that this is the only permissible interpretation, that the HRS needs to be applied literally and rotely in every situation, then, as applied, we believe this factor of the HRS is contrary to the underlying statute, and therefore, as applied in this case, is invalid.
Okay, so EPA says you're too late. The regulation was promulgated in 1990, I think, and you had 90 days. Did Troy own this property at the time this regulation was promulgated?
Yes, Your Honor. The regulation was promulgated in the mid-'80s, and Troy came into existence and owned its property in 1980.
So what's your argument regarding why you didn't have to comply with the 90-day review period?
Fair question, Your Honor. I think this situation fits squarely within the line of cases by this court, recognizing that later challenges can be recognized. Most recently, the court recognized it in the NPL context in the genuine parts case in 2018, where the particular application is not something that could have been contemplated at the time. And so we feel that there's ample basis for the court to look at the validity of this factor of the HRS as applied in this case under the genuine parts and other precedent for allowing later challenges.
All right. Judge Katsas, Judge Randolph, do you have any further questions?
No.
All right. Thank you. We'll give you some time on reply. Mr. Goldberg, we'll hear from Ms. Chen.
Thanks.
Good morning, and may it please the court. Sue Chen for the United States. There's no dispute that there's at least 7,300 pounds of mercury at the Pearsons Creek site. And in scoring the site, EPA disclosed detailed documentation supporting the wetland score, and it also accounted for potential mercury migration in threatened fishing grounds. First, the wetlands, and I'll talk first about the disclosure aspect and then EPA support for the wetland delineation. At proposal, EPA put Troy on notice of the wetland that's the basis for the wetland score. It provided sufficient factual detail for informed commenting by disclosing the wetland's location and length. It also disclosed the logbook and data forms, which provide detailed documentation of the area's hydrology and vegetation and soil conditions. There's no requirement to also disclose that documentation in photographic form.
Why not give them the location of the soil bores?
Because those GPS coordinates add no meaningful information that could affect the score.
Well,
what matters?
Why not? This case is on the razor's edge. We're talking, this designation rises or falls on 300 feet of difference. There's a difference between 0.1 miles and 0.15 miles.
So let me...
Presumably, you think there can be variance within a range of a couple of hundred feet, because I assume you didn't put in 9 soil bores for nothing, and 6 of them are coming back negative.
2 points on that. The first is the margin of error is actually not as small as you think, because you need only a 0.1 mile stretch in the zone of actual contamination. We had 0.15. So, I'm sorry?
So the difference is 0.05.
Right, but on the map, that line can be up to a third shorter, and it will not make any difference to the score. The second point is what matters for the wetland score is that 0.15 mile stretch in the contaminated zone, and that information was disclosed at proposal. There was a map at JA36, which is reproduced in our brief. It shows you the wetland in pink and the contamination in yellow. There's a logbook and the data forms. And the logbook at JA493, along with the data forms, tell you that there are 3 locations. There's 3 soil sample locations on...
And 6 or 7 that are negative.
Right.
Wouldn't it, in that context, where you're talking about what seems to be a pretty small amount of land as far as geology or hydrology goes, and different results as you move down that segment, most of which are negative, it would seem like the difference between a few hundred feet here or there could be critical.
So I think there's a misunderstanding about how the soil boring locations are used. So let me skip ahead and talk about the basis for EPA's wetland delineation, but I do want to return to the GPS coordinates. So EPA's basis for concluding that the wetland exists and its continuity is a holistic analysis by the wetland scientist based on his observations. So what happens at these delineations is that the wetland scientist is on the scene, he sees something that looks kind of like a wetland, and he's going to take a closer look. He's going to look at the hydrology, he's going to look at the vegetation, and he's going to take a soil sample to check out the soil conditions. And let's say he decides, based on his professional judgment, that that location is a wetland. The next thing he does is he's going to look around and see, well, how long does this wetland continue on for? Now, if the next 30 feet look like the location that he just said is a wetland, then he's probably not going to do anything. But if at 35 feet, things start to change and look different, he's going to take a closer look, and that might involve taking another soil sample. So the fact
that fact cuts against you, because that expert making all of those judgments that you summarize chose to take 9 different samples.
He is taking different samples to see where the wetland ends. He needs to take samples both in the area that he thinks is a wetland and areas that he thinks that's not, because the main goal of the wetland delineation is to figure out where the wetland begins and ends. He can't take soil samples from just what areas he thinks are wetlands, because that doesn't tell him about where the wetland ends. So, Troy is talking about how these soil sample locations are not next to each other. Well, they're not supposed to be. That's not how the wetland delineation works.
No, I understand that, but it seems like his expert judgment is he needs granular information at the level of hundreds of feet. As you say, it might have been his expert judgment that he looks at one point in a 1/10 of a mile segment, and he knows that vegetation doesn't change within 0.05 of a mile, so he says, good enough, I'm done. But he didn't do that. He kept testing different bores, and the results came back mixed. 6 of them were negative. So,
right, and those areas are not part of the wetland. But in the area that he saw were wetland, he put down wetland flags, and I mean that's the area that he's decided are wetlands. The soil borings that showed up where he concluded is not a wetland are not part of the pink line that you see on the map.
it seems like it's a pretty marginal determination where the detail might have mattered.
And he took account of the details. The whole point of this exercise is to figure out.
Did, but your friends on the other side didn't appreciate the full significance of, didn't have all the facts that bore on, what do you make out of the fact that 6 out of the 10 or 9 soil bores are coming back negative. And I understand your theory. Your theory is, well, those bores are too far up the hill from the stream, but maybe not. Maybe they're coming back negative because the wetland areas, instead of being 0.1, are 0.01.
But you look at the data forms that tell you the wetland conditions in those areas. There's also the logbook at JA 492 that summarizes the wetland scientist observations about that wetland along the creek. And you see the pink line that is drawn up there based on the GPS coordinates that EPA collected at the scene. So that's how you know that EPA determined this is a 0.15 mile stretch.
What in the original disclosure described how the EPA determined that the 1.15 mile area was actually contiguous?
So if you look at the map at 2 places. If you look at the map at JA 36, the key tells you that the wetland is shown in pink, and the line that represents the wetland is a continuous pink line. So that tells people that EPA thinks that there is a continuous stretch of wetland. Then you look at JA 492, which is in a logbook that talks about a small fringe wetland at the base of a steep slope along the east edge of Pearsons Creek. And then it describes where that is on the 429 Delancey property. The other thing I'll note is that, again, this is a wetland delineation.
My question to you was what in that original disclosure tells why and how EPA determined that it was continuous?
It's based on the data forms for the soil sample locations and also the logbook, which tells you about that wetland along the east edge of Pearsons Creek. That's the documentation. And again, the context is important because if EPA had seen discontinuities, it would have noted that. It noted the places when it took soil sample locations that are not wetlands. So, but going back to the GPS, I just wanted to make clear that you know from the logbook that there are 3 soil sample locations that are on the wetland. They're SB 1, 4, and 7. So by that fact, you know that these 3 locations are on the pink line that represents the wetland in the map. And so all that the GPS coordinates tell you is their exact placement on the pink line, which doesn't help you with disproving the wetland and it does not otherwise affect the score.
No, but if you look at the map with the GPS coordinates,
Mm-hmm.
it seems it likewise shows the six other coordinates seem to be right at the stream as well.
They're very close, and I do want to take this opportunity to respond to Troy's argument about SB8, which they say lacks wetland characteristics, but is shown as being on the wetland in this map at JA 379 that you just pointed out, Judge Katsas. And setting aside the fact that Troy waived this argument by not including it in the opening brief, SB8 is actually a good illustration of another reason why GPS coordinates are not helpful here. If you look at the data form for SB8, which is at JA 508 to 509, it tells you that this location is, quote, 5 feet from creek on steep slope. So what happened here is that the horizontal distance between SB8 and the wetland was pretty close, and that's why on the map it's showing up as being on the wetland. But in reality, SB8 is actually sitting above the wetland on that steep slope. The problem, of course, is that GPS coordinates don't tell you elevation, just longitude and latitude. And so when it's trying to represent this three-dimensional world on a two-dimensional plane, sometimes it's here, it can be misleading. But we do have that
Yeah, I understand that, and it is a plausible reading of the guidebook that the results that are coming back negative are coming back negative because the soil bore is elevated from the stream. But that doesn't seem self-evident, and you were the target of this designation. I would think you would surely be interested in exploring whether those results are coming back negative because the bore is higher than the stream bed, or whether they're coming back negative because the vegetation is just changing.
Well, actually, you do know that information because there are data forms for every single soil boring location that describe where that location is. It also documents in a lot of detail the hydrology and vegetation and soil conditions. And, so that gives you a lot of information about why that area might not be a wetland. Turning now to the food chain threat, unless there are any more questions on the wetland. Okay. EPA accounted for potential mercury migration over this 15-mile target distance limit in two ways. First of all, in the response to comments, EPA explained that during major storms, Pearsons Creek flows very fast and the mercury-contaminated sediments are not contained. And so there's the potential that the creek is washing out those sediments into Pearsons Creek and the rest of the estuary, which in the middle of a major storm is not going to be sitting still either. Troy's calculation at JA 96 ignores movement in a channel. They're assuming that water stays still in a major storm in a channel and the estuary. So EPA has shown potential mercury migration in this limit. The other way that EPA has shown that is that its regulations on scoring the food chain threat reflect the agency's judgment that mercury release can potentially migrate 15 miles downstream and threaten the fishery. Back when EPA promulgated these regulations, it had to decide where to draw the line. And to make that decision, one of the factors it considered was how far a contaminant can travel downstream before being diluted to a point where it's no longer important in the risk analysis. So
does it matter what the contaminant is?
It does. And so elsewhere in the score, there is this thing called the persistence factor for each substance that accounts for how likely it'll degrade in that 15 miles. And as we noted in our brief, mercury is among the most persistent factors that EPA encounters at these sites. So there's not going to be a lot of degradation over the 15 miles. And let me just respond to Troy's point about challenging.
Excuse me, this is the regulation 4.1.3, is that right?
So there are two regulations. The actual food chain score is 4.1.3.3.1.
Do you realize that in your addendum with that Part 500 regulation, the only thing you left out is 4.1.3?
I am pretty sure we included the exact regulation. We might not have included the 4.1.3, which is the one, the more general regulation. But we'd be happy to file that as a supplement.
I can get it. It's annoying. I had to get it off the CFR. So.
I am very sorry, Judge Randolph. But you know, Troy is saying that somehow it is challenging the regulations, but they have not petitioned for review of the regulations. And in their opening brief, they certified that the ruling under review is the listing decision. They didn't mention the regulations. So I mean, you can't even consider those regulations at this point because they're not before you. And I just want to make some general observations about the hazard ranking regulations, which Troy says, you know, they're very formulaic, they're very mechanical, and yes, those regulations can be formulaic, but that's a virtue and not a bug, because the statute at 42 USC 9605 A8A tells EPA to add sites to the national priorities list based on relative risk. So EPA has to consider a site's risk relative to other sites. I mean, that's how you know what your priorities are. And that's why it's important to use the same formula across different sites. If you fiddle around with the formula, if you say that, well, this site, we're going to consider fisheries only 2 miles downstream, but at that site, it's going to be 15, then you really compromise EPA's ability to do the relative risk assessment that the statute requires. I'm happy to answer any more questions.
All right, Judge Randolph, Judge Katsas, anything else for respondent?
No.
All right, thank you.
Thank you.
Ken, Mr. Goldberg, we'll give you 2 minutes for rebuttal.
Thank you very much, Judge Wilkins. Just a couple of critical points that I think would be worth the court keeping in mind. First of all, with respect to the wetlands delineation, it's important to recognize that the scientists who went to visit the wetlands in no place either assert that there's 0.15 miles of wetland or that those wetlands are continuous. Neither the handwritten notes or the field log nor the 90-page document, which incorporates those notes along with other documentation that EPA provided at the final, actually have the scientist making that finding. EPA makes that finding. EPA drew a line on a map without providing any anchors, without providing any indication of why that pink line is where it is. And, you know, the 0.15 miles shows up in point at page 58 of the joint appendix, which is separate from the initial field notes. So this idea that, oh, there's 0.15, it's this pink line. Well, wait a minute. I think Troy is entitled to ask, and this court is in a position to compel EPA to make sure that it provides enough information to know where that line is anchored and why it is where it is. On the food chain point, I just point out that the reflexive application of the HRS is the same for the discharge from Troy as it would be for a mercury fever thermometer breaking and being observed flowing into the creek. EPA certainly isn't arguing that it, because of the HRS, has to automatically give that thermometer break a score of 20 on the HRS. But that's the result of its reflexive application of the hazard ranking system. And that's why it needs to be able to consider additional record evidence, as Troy has submitted in this case.
All right, thank you. We will take this matter under advisement. Call the next case, please.
Case number 19-5321, Owner-Operator Independent Drivers Association, Inc., et al., appellants versus United States Department of Transportation et al. Mr. Stinson for the appellants, Ms. Lopez for the appellees.
Good morning, Mr. Stinson. We'll hear from you.
Good morning. May it please the court. My name is Charles Stinson, and I represent plaintiffs' appellants Klint, Mowrer, and Fred Weaver, Jr. I'd like to reserve 2 minutes for rebuttal. The issue facing this court on this appeal is a straightforward one. Can commercial truck drivers, like Mr. Mowrer and Mr. Weaver, hold FMCSA and the other defendants accountable under the Fair Credit Reporting Act when the defendants distribute inaccurate and damaging personal information about these drivers to these drivers' potential employers through the Pre-Employment Screening Program, or PSP? Congress has answered this question in at least 2 ways. Congress specifically intended that FMCSA's driver reporting under the PSP be held to account under the FCRA, and Congress generally intended that federal agencies, when they do the type of reporting covered by the Fair Credit Reporting Act, be subject to that statute, as is the case in PSP.
And I'll just be clear on the claim that is before us.
Yes.
The claim that is brought under the Fair Credit Reporting Act.
Yes, Judge Wilkins, that is correct.
So the cause of action is based on the FCRA, or the cause of action is created by the FCRA.
Yes, Your Honor.
And it's a cause of action for damages at this point, right?
Yes, correct. In the previous appeal, the other other equitable injunctive declaratory relief were removed from the case.
So why isn't the first question we have to determine whether, because it's a subject matter jurisdictional question, whether Congress waived sovereign immunity under the FCRA for damages claims? Why isn't that the first thing we have to do?
Right, Your Honor. Well, the district court did not address the defendant's immunity on this appeal, although in the first proceeding, district court did note that under the FCRA, the Congress waived defendant's sovereign immunity, and it followed the Seventh Circuit decision in Borms, both sides of the decision, and it followed the analysis in Borms. The district court on this time around decided not to address the immunity issue, although yes, you're of course correct that this case could be decided on the immunity issue. And that question is, well,
You need to win on both, right?
right, yes. The 2 questions are closely related as to whether defendants qualify as FCRA persons and FCRA consumer reporting agencies. The current version of the statute imposes liability on any persons who violate the statute. The pre-1996 version of the statute imposed liability on consumer reporting agencies who violated the statute. But as the definition of consumer reporting agencies is key to the definition of person, really the definition of person is what controls, at least what guides the court in whether immunity has been waived. And in this case, as the Seventh Circuit found in Borms, the language that Congress used is clear. Section 15 USC, section 1691A, subsection B, includes government and government entities in its definition of persons, and it includes no reservation of the federal government or otherwise limits the statute's or definition to state and local government. And
is the federal government a person as that word is used in the section subjecting persons to criminal liability?
I think that is a defendant, an argument the defendants made. It's an argument relied upon in the Ninth Circuit in Daniel that would lead to that result. But I think that if you read that statute in context, it's 1691 Q, I believe, that imposes criminal liability for persons who obtain consumer reports under false pretenses. And that's a very limited criminal liability section, and it's unclear that that the federal government and not an erstwhile agency employee could ever violate that statute. And so whether the criminal liabilities, I don't think stops the government from being a person in the other provisions of the statute.
So, sorry, was that a yes or a no?
I don't believe that the federal government or any government would be a person under that provision of the statute. Employees could be.
So if that's true, don't we need more reasoning on the sovereign immunity waiver than just the syllogism? Here's the definition of person. It covers the federal government. Persons are exposed to civil damages liability, QED.
Yes, Judge Katsas. I think if you look at not only is person defined to include governments, but the TSP statute itself, 49 USC 31150, which incorporates, if there's any ambiguity in the definition of person in 1691A subsection B, then the TSP statute would subject defendants' TSP reporting to the FCRA. If you read the two statutes together, then it's clear that Congress intended that when the federal government does specific type of consumer reporting covered by the statute, then it is a person that's liable under the statute and subject to the statute's strictures and other procedures.
But can't Congress say that the government should comply with certain procedures that are set forth in this statute, and at the same time decide that we're not going to waive sovereign immunity so that you can sue the government for damages if they don't comply with the statute? You might be able to get injunctive or declaratory relief pursuant to the waiver of sovereign immunity in the APA, but we're not going to subject the government for damages. Can't Congress make that sort of a determination when they say that the government will be bound by a statute?
Right. Judge Wilkins, yes, I suspect that the government can do that, but the government did not do that here. In other statutes where the government has, or where Congress has defined the scope of persons potentially liable under the statute to include governments, they have withheld certain kinds of liability from the federal government. They didn't do so here. The Equal Credit Opportunity Act, which is another financial remedial chapter of Title 15, the government, Congress specifically reserved certain kinds of liability from the government in its liability provisions.
Mr. Stinson, I want to go back to a question that you were asked by Judge Wilkins, and that is whether we have to decide sovereign immunity before we get to the merits.
I think I don't know that you have to. I think the questions are interrelated. Whether
well, there's a case that the law of the circuit is from In Re Sealed case in 1999, and it said, I'm going to read it to you. It just said, or hybrid status of federal sovereign immunity, we are not required to decide that issue before the merits.
I'm sorry, Judge Randolph, you cut out at the beginning. I didn't hear the beginning of the quote.
Well, there's precedent in this circuit saying we don't have to decide sovereign immunity before deciding the merits.
Right, and so I think
supports your position, but you didn't cite the case.
Right, I think you certainly could, but you're not required to. And as I said, in this instance, the two issues are interrelated, as they're both determined by the scope of consumer reporting agencies and persons under the Fair Credit Reporting Act. And I'd just like to touch briefly on the district court's, the crux of the district court's decision, which was that defendants do not assemble driver information for the purposes of including that information in reports to third parties. And the district court erred because it ignored the reality of PSP. This is the requirement for a consumer reporting agency under 1691A subsection F. In PSP, defendants extract 3 categories of data from their overall MICMAS motor carrier database. They extract those 3 categories of data and they assemble them into a report. The express and exclusive purpose of that assembly into a PSP report is to provide those reports to third parties, in this case, potential employers who are making FCRA decisions, in this case, hiring. If there are no further questions, I see that I'm out of time, and I'll reserve the remainder for rebuttal.
All right, thank you. We'll give you some time on rebuttal. Ms. Lopez, good morning.
Good morning. May it please the court, Carolyn Lopez on behalf of the government. Here, as your honors have pointed out, for plaintiffs to prevail, they would have to show both that the agency is somehow transformed into a consumer reporting agency when it's carrying out legislative directives intended for safety purposes, and that the United States has waived its sovereign immunity with respect to damages, and it can do neither.
Decide sovereign immunity first?
No, Your Honor. If Your Honors believe, as the government argues, that the agency simply isn't a consumer reporting agency that's governed under the Fair Credit Reporting Act, the question of whether damages would apply if those provisions, in fact, applied to the government need not be answered here today.
Well, but I'll check the case Judge Randolph cited later, but I thought sovereign immunity went to subject matter jurisdiction.
I'll give you the citation. It's 192 Fed 3rd at page 1000.
Thanks.
In any event, I'm happy to address either the consumer reporting agency language or the damages provisions first, as your honors prefer. The United States, certainly, it's a bedrock principle on waivers of sovereign immunity with respect to damages that they have to be clear and unequivocal. There's no clear and unequivocal language in the FCRA subjecting the government to liability here.
So let's talk about that. Do you agree that the definitional clause is clear and unambiguous in extending to the federal government when it says person means any individual, corporation, etc., or government?
Yes, Your Honor. It does include governments within, so including state governments, federal government, foreign government. Yes, Your Honor.
And then it would seem to be equally clear from both text and structure. Those words appear in a definitional provision that is expressly said to define what that word means across the entire statute.
No, Your Honor, for 2 reasons. One based in a Supreme Court case, and one based, as Your Honors were discussing earlier, as discussed in the Ninth Circuit's decision in Daniel and the Fourth Circuit's discussion in Robinson, based on the text of this particular statute. So starting with that Supreme Court case, in the employees case, which is 411 U.S. 279 at pages 282 to 285, the Supreme Court explains that, for example, and there we're talking about the Fair Labor Standards Act, where state governments were included in the definition of employer, and there was a separate liability provision for employers. When there's congressional silence as to whether or not that definitional provision was intended to waive state sovereign immunity with respect to liability, Congress shouldn't find that waiver there. The same principle applies here.
Okay, is that case in your brief?
I don't believe it's in the brief. I just wanted to provide sort of context as to sort of how we were analyzing this. And then
411 U.S. at 282?
Through 285, yes, Your Honor.
Okay, I'll check that too. Just starting with text.
Yes, Your Honor.
The definition says, for the purposes of this subchapter, and this subchapter means all of FCRA, right?
Your Honor, I think what's helpful here is to take a step back and look at the way that the 1970 version of the statute as enacted, how all of those provisions work together.
I'll let you do that in a second, but before we get to structure and drafting history, let's just talk about text. And text seems awfully clear.
No, Your Honor, I disagree. As the Supreme Court emphasized in both Daniel and, as the Ninth Circuit emphasized in Daniel and the Fourth Circuit emphasized in Robinson, if one were to read person across the entire text to mean both state and federal government across everything, it would lead to absurd results. And so that's both the criminal provision that Your Honor raised earlier, but also it's actually, if one were to look at this consumer reporting agency provision in the original text, if by the mere inclusion of governments and persons, states, for example, could be included in consumer reporting agencies, that itself would be unconstitutional because it's enacted under the Commerce Clause, and private suits for damages cannot be enacted against the states pursuant to Congress's Commerce Clause powers.
The 11th Amendment? Is that because of the 11th Amendment?
Yes, Your Honor, and so that's a Seminole tribe decision.
So the abrogation is unconstitutional as applied to states. So what? That statute covers states and it's unconstitutional as applied.
It's yet another reason, along with the fact that the application of the criminal
one, that's a good point in your favor, but I mean, it's really an argument that, to me anyway, it sounds like an argument that absurd consequences trump text.
No, Your Honor, and I think if I might, with your indulgence, just talk about how it made sense for Congress to include persons and why it would have done so in the original text without actually imposing liability. And again, it has to be clear and unequivocal. If there's a plausible reading of the statute that doesn't impose liability, then liability should not be imposed. And here, if one looks at the original statute altogether, so that's at 84 Stat 1127, there are a number of provisions. So for example, Section 607 and Section 604 that regulate consumer reporting agencies and the permissible uses for which they can provide information to persons. And there, it's quite clear that they still have to follow those rules when the person to whom they are disclosing includes governmental agencies. So for example, 604D applies to when governments are making beneficiary decisions. It's only a government that would do that. And that's underscored by the original Section 608, which creates a limited carve-out for additional disclosures to federal agencies by those consumer reporting agencies in certain circumstances. And so it made sense for Congress. There's certainly a plausible reading of the 1970 Act that doesn't just depend on the absurd results for why it would have been included in the definitional section for those purposes, but not actually with respect to the liability provisions. I would also like to just talk about why the agency doesn't come within the definition of a consumer reporting agency in the first place, if there aren't further questions on the damages at this time. As the district court correctly concluded, when Congress mandated that the agency give motor carriers electronic access to previously assembled driver safety reports from the agency's central database as an alternative to FOIA requests and to promote the public safety, Congress did not implicitly transform that federal agency into consumer reporting agency for purposes of the Fair Credit Reporting Act. And I think here it's really important to understand how this all works together, and this is something that the district court went through. So it happened in a series of sort of congressional enactments. First, Congress mandated that the agency collect and compile driver safety information from crashes and inspections at the roadside, and that it do so for a variety of safety purposes, including rulemaking and enforcement actions. And at that time, motor carriers were able to get that information through FOIA requests with driver consent. Subsequently, Congress said at Section 31150A and C that the agency was to provide electronic access to the reports from that same central database. So no new assembly, it has to be an exact match or snapshot, as the district court recognized. And the purpose there too was to promote safety, and that's in fact borne out, as the agency has emphasized, with employers who are regularly using these reports seeing a decrease in crashes of 8% and a decrease in driver out of service orders, which only apply where the driver
But
either.
it seems to me that B1 says that the agency is to ensure that any information that is released to such person will be in accordance with the Fair Credit Reporting Act. You don't get much more explicit than that. What does will be in accordance with the Fair Credit Reporting Act mean?
Absolutely, Your Honor. So 2 points there. First, it actually underscores that the agency, by the terms of the Fair Credit Reporting Act itself, which is the cause of action sought here, is not already directly regulated as a consumer reporting agency under that statute, because otherwise that would just be surplusage. Second, when read in context with the rest of Section 31150B, which can be found at addendum page 1, what it actually appears to be referring to is not any new, certainly no clear and unequivocal waiver with respect to damages. There's no mention of damages there at all. But rather, when you read the language together with the other parts of that provision, so B2 instructs the agency to ensure that the program requires driver consent. B4 instructs the agency to create a procedure for correction. What it's doing is making sure that that when a motor carrier either collects information.
But the problem with that argument is that Congress said those two things. It didn't need to say will be in accordance with the Fair Credit Reporting Act. They could have just said, make sure that you get consent and that you have a correction procedure as part of this program. They didn't need to say will be in accordance with the Fair Credit Reporting Act if that's all they intended to do.
So yes, Your Honor, I think actually it's one thing that's helpful to note here is that there are parallel provisions in the Fair Credit Reporting Act that specifically apply to motor carrier employers and what they have to do when they get similar information directly from a consumer reporting agency instead of from the agency. And so those can be found at 15 USC 1681B, parens B, parens 2, and parens 3. And there, those regulations. Did
you point that out in your brief? Because I don't remember seeing it.
No, Your Honor, it's not in your brief. But in response to your question, what we did say in our brief is that what that was intended to do is to really ensure that the agency was operating in parallel to the spirit of the FCRA and the Privacy Act, and particularly concerned with consent as emphasized in the conference report at 109-203, page 991.
May I interrupt you before you run out of time? You're saying that DOT is not a consumer reporting agency. You don't mean to agree, do you, that these commercial accident and inspection reports are consumer reports?
No, Your Honor, they're not. Consumer reports are issued, definitionally are provided by consumer reporting agencies. And so that's why what Congress instructs the agency to do is to create parallel provisions requiring driver consent and giving them the authority to set up their own procedure. If they were already regulated as consumer reporting agencies because they were providing consumer reports, then there would be no need to instruct the agency to create its own procedure because the FCRA contains a comprehensive procedure for corrections. And so it's really reading all of those things in harmony that gives meaning to every provision of Section 31150B read together and aligns with Congress's purpose in enacting the statute. And I did just want to emphasize that, every court, there's good reason that every court and the FTC in the 50 years since the FCRA has been enacted has rejected attempts to make federal agencies or state agencies acting pursuant to legislative safety directives into consumer reporting agencies under the FCRA. I see I've gone well over my time. If there are no further questions, we respectfully ask that the court affirm.
Any further questions, Judge Katsas, Judge Randolph?
No.
All right. Mr. Stinson, we'll give you 2 minutes for rebuttal. I'm listening. I just have to step away for a second.
Thank you, Your Honor. I just have a couple of brief points. To address Judge Randolph's question there towards the end, these PSP reports certainly could be consumer reports. They're personal information that's distributed for the purposes of making a hiring decision, which is a decision covered by the FCRA. So they could be consumer reports. Secondly, I want to say that while the cases that Defendant's Counsel refers to have not found that the federal government is a consumer reporting agency, those cases do not involve an instance where Congress specifically directed an agency to do consumer reporting. Here, Congress directed FMCSA to do the consumer reporting covered by the statute, and FMCSA did that. They assembled, they created a system whereby driver information is assembled into a single report that is provided to potential employers who are making hiring decisions.
What does an accident report have to do with credit worthiness or credit standing or financial wherewithal?
Judge Randolph, nothing, but the FCRA is not limited to those purposes.
What about an inspection? What has that got to do with it? I mean, one of your clients there was some kind of latch that had too much play in it. That didn't have anything to do with whether he was worthy of the extension of credit, did it?
Yes, of course, that's correct. But the FCRA applies to information regarding a person's character, their mode of living, and is that.
But that goes, yeah, the character, it all relates back to credit worthiness. I mean, you could say that you don't want to extend credit to somebody who's been convicted of 10 felonies over their life.
Right, Your Honor. But the Fair Credit Reporting Act, its definition of consumer report expands well beyond what would be considered traditional credit reporting to include information used in making employment decisions, and that is specifically what PSP reports are by design. Section 31150, subsection C, expressly provides that these are reports to be used to make hiring decisions, and only.
Well, you don't want to hire, an employer would not want to hire a deadbeat, right? I mean, that's what that means.
I think there has not been a dispute in this case that the type of information that's contained on PSP reports is not the type of information covered by consumer reporting agencies, covered by the definition of consumer reports, notwithstanding defendant's argument that they're not consumer reporting agencies, so therefore they can't produce consumer reports. But Congress here, we're not asking to hold the entire federal government accountable under the FCRA for every record-keeping decision it makes, which is what is addressed by the cases cited by defendants. What we're asking here is for to hold the FMCSA accountable when it is, by design, doing consumer reporting from the directives from Congress. Thank you, Your Honor.
All right. Thank you, counsel. We'll take the matter under advisement.
Case number 19-5254, Fresno Community Hospital and Medical Center, doing business as Community Regional Medical Center et al., appellants, versus Alex Michael Azar II, Secretary, United States Department of Health and Human Services. Ms. Pagonis for the appellants, Ms. Schoen for the appellate.
All right. Good morning, Ms. Pagonis. We'll hear from you.
Good morning, Your Honors. May it please the Court, Katrina Pagonis from Hooper, Lundy & Bookman on behalf of Fresno Community Medical Center and 683 other Medicare participating hospitals. I'd like to reserve 2 minutes for rebuttal. This appeal concerns the federal court's power to review the Secretary's unlawful continuation of a 0.7% payment reduction resulting in an $840 million yearly cut in hospital payments that the appellant hospitals timely and properly appealed. The district court, misapplying the preclusion statute, dismissed for lack of jurisdiction, and in doing so erroneously concluded that review would only be available if the hospitals could establish the payment reduction was patently unlawful. The district court, however, was writing without the benefit of DCH Regional Medical Center versus Azar and American Hospital Association versus Azar, both of which confirm that the same agency error can simultaneously render a jurisdictional bar inapplicable and compel setting aside the agency action. So it is here. Section 7B5 of the TMA only precludes review of determinations and adjustments made under a statute that explicitly prohibits the Secretary from continuing payment reductions into subsequent years. And thus, the Secretary's continuation of the 0.7% fiscal year 2017 adjustment to reduce payments in 2018 is not subject to preclusion under the plain text of the statute.
Didn't Congress in 2016, when it enacted the MACRA, essentially direct the Secretary to, I guess, not restore completely a payment adjustment that had been made in prior years by limiting the, not sure the right term to use, but the restoration to a total of 3.0%?
Yes, Your Honor, but there with some caveats. When Congress acted in 2015, CMS had indicated for 3 years that, or actually for 2 years at that point, that it anticipated making a total 3.2% negative adjustment after ATRA that would be loaded into the rate by fiscal year 2017. And so Congress said, instead of the offsetting adjustment for that 3.2% coming in 2018, we're going to pay for a Medicare physician payment rate fix. With a ladder of adjustments through 2023, with the residual to be fully restored in thereafter in subsequent years, because it's very clear these temporary adjustments can't continue forever. And so, but when it did so, Congress didn't just say this is in lieu of the positive adjustment that would apply in 2018. It said estimated to be 3.2%, because it was acting well in advance of CMS's finalization.
But my point in the question, well, there are several points in the question, but one of them is that Congress directed the Secretary to do something that is on its face contrary to what you say the plain language of 7B2 allows.
7B3 adopts another set of adjustments. So, under macro alone, it essentially adopted a net negative 2.7% reduction. But because it was being done before Congress knew what money was on the table, it uses slightly different language. Congress was, I have no concerns with Congress, retaining some funds to achieve very specific congressional purposes. But here we have a surplus, unanticipated 0.7%, $840 million each year that Congress did not expect or anticipate and therefore did not speak to. And because Congress did not speak to that 0.7%, the default rules remain, which is that the ATRA adjustments after fiscal year 2017 need to be eliminated. And so that, it's narrowly construing 7B3 against that clear backdrop that in ATRA it says those adjustments only apply for fiscal years 2014, 2015, 2016, and 2017. And in 7B2 it says it needs to be removed from the standardized amount in a subsequent year.
So anytime, if the Secretary were to believe that an adjustment needed to be made, and decreased the standard rate by a certain percentage and failed to, I guess, restore the standard rate to the base rate in a future year, under your theory, that would always be reviewable because that's not an adjustment.
Yes, Your Honor. The continuation of an adjustment is distinct from an adjustment made under the statute.
And what court has ever held that?
Well, we start with the narrow construction of the preclusion statute, and this is, say, most analogous to this court's interpretations of the preclusion statute in the outpatient prospective payment system, which refers to the development of a classification system under paragraph 2, including the establishment of other adjustments, including a method under T2F, et cetera. And in each of those cases, Amgen's and American Hospital Association versus Azar and others, this court has said that it will look at the consideration of the merits and jurisdiction merge when determining whether, the scope of the bar. And when an appellant is saying that, for example, this is not a method under subsection T2F, then that gets reviewed on the merits, because the question of the merits and the jurisdiction merge under the language of that preclusion statute. And this calls back to the requirement to narrowly construe a preclusion statute on unless the secretary has and only apply preclusion if the secretary can present clear and convincing evidence that Congress intended to preclude review.
You think it's a narrow but fair reading of this preclusion statute to say review is precluded, but only if the government's position is right on the merits? That's what you're saying.
Yes, Your Honor, with a caveat. Certainly we couldn't have come in 2017 and said that the adoption of the net negative 3.9 adjustment was unlawful because that is the making of an adjustment under subsection 7B1B2. But here we have, the making of the adjustment, the positive 0.4588, but we have this unspoken to net, negative 0.7 that Congress didn't address, and it is being carried over. If we could take, for example, an extreme circumstance, if we have 2024 and the secretary keeps the 0.7 plus the residual 0.2412 on the books, right? That continuation of the net negative adjustment into 2024 would violate 7B2. It would also violate 7B4, which says that, makes triply sure that an adjustment can't continue after 2023. So the continuation of an adjustment is something prohibited by Congress. And Congress was not speaking to the continuation of an adjustment in the preclusion statute.
The governing statutes, MACRA, Cures Act adjusts MACRA, which gives a very specific command to make an adjustment. That word used is adjustment, which is one of the same words that triggers the judicial review bar in 7B4, and all of this is done under 7B of the TMA.
Yes, Your Honor. However, 21st century
specific agency action under review in its label and in its substance is an adjustment to the standardized amount.
The positive 0.4588% adjustment is an adjustment. However, the retention of the 0.7 is something distinct and separate in kind. Congress, in 21st century cures, knowing that the final ATRA adjustment was 3.9%, left in the statute 3.2%. And I think Congress's intent here is pretty clear from 21st century cures. They go down to the 10,000th to get an adjustment, an additional negative adjustment of 0.0412%, which yields $60 million, according to the Congressional Budget Office. So they're searching for $60 million when there's $840 million on the table had they simply changed 3.2% to 3.9%.
The problem that I have with this argument is that the agency had said, the secretary had said that it was going to reduce by a total of 3.9%, I think in August of 2016. And then 3 months later or so, Congress writes this statute, and they don't say that's wrong. It should be a total of 3.2%. I mean, your argument about Congress being specific cuts against you, because you your clients had this battle in the commentary when the regulation was being promulgated about whether the secretary could do what it did, and it disagreed with you, and then Congress acted, and Congress didn't correct the secretary. I mean, that weighs against you, if anything.
The back and forth, Your Honor, in the 2017 rulemaking cycle concerned whether ATRA gets to a negative 3.2% or a negative 3.9%. And that is not the unlawful conduct that we are arguing here. We do not take issue with the making of an adjustment in fiscal year 2017.
But you argue that Congress intended for the adjustment to be no more than 3.2%. And Congress could have said so after the secretary said, we're going to make an adjustment of up to 3.9%.
Well, Your Honor, I would take the view that Congress did say so. The secretary said we're going to end up with net negative 3.9%. Congress left in language it said estimated to be 3.2%. And did not adjust it to reflect that additional 0.7% or speak to that 0.7%, which is, 20% higher than that 3.2% spoken to in the statute. And at that time, whether, the CMS had not yet taken the position that in 2018, it was going to also continue the 0.7% reduction. So Congress had no way of knowing in 21st century cures that CMS was going to take the view that that 0.7% carries over, despite Congress not having spoken to it.
Excuse me. The 0.04588 is an adjustment under the Act, right?
Yes, Your Honor.
Right. So what you're telling us is that is an improper, incorrect adjustment, and yet the judicial review provision says it doesn't say adjustments made by the secretary. It says any adjustments under this subsection are not reviewable. So we can't review the 0.04 and whatever and say it's too small.
Well, Your Honor, we are not asking this court to answer the question of whether the 0.4588 is appropriate. We are taking our view, which we think is supported by the plain text of the statute, is that there is a 0.7% that subsection B5, B3 does not address. And so, the 0.4588, which gets you to a net negative 2.7412, apologies, Congress went down to the 10,000th of a percent, is not on the table for review. But the 0.7% that is not addressed in B3 is absolutely on the table, because Congress said in B2 that was only for discharges occurring in fiscal year 2017.
Which is an argument that the adjustment that the agency made, the upward adjustment the agency made, wasn't high enough because they didn't take account of other provisions in the statute.
you know, it is. Yes, Your Honor. You know, at the end of the day, when we load in everything and adjust the rate, we're arguing that there was, you know, an $840 million underpayment that would be cured by a positive 0.7% adjustment. But it's not that it wasn't big enough or anything along those lines. It wasn't spoken to by Congress. And if Congress has not spoken to it, then the backdrop that Congress made triply sure was in place with the language in 7B2, the language in 7B1, B2, both of those, you know, make very clear that the default rule is it evaporates in 2018. And Congress not having spoken
that just assumes you're assuming the truth of your argument when you say Congress didn't speak to it. That assumes when it said 0.04588, it wasn't saying, and we really mean it. This is the adjustment you should make. If that is what Congress did, and it certainly seems to be on the face of it, then it did speak to the 0.07.
Well, viewed another way, the positive 0.4588 is not just said in isolation. It's 0.4588 in lieu of the adjustment that otherwise would apply, which is estimated to be 3.2%. That gets you to a net negative 2.7412%. That is what Congress spoke to. Congress said UCMS retain a net negative 2.7412% with some small margin for error, but did not authorize the Secretary to retain anything more than that. I see I've gone over my time, and I'll reserve the remainder for rebuttal if there are no further questions at this time.
All right. Any further questions? All right. Thank you. We will hear from counsel for appellee, Ms. Schoen.
Good morning. May it please the Court, Sharon Schoen on behalf of the Secretary of Health and Human Services. The underlying dispute in this case is about the amount of the adjustment that the Secretary was required to make in fiscal year 2018. The statute, in particular subparagraph little Roman 3, which is on JA 245, directs the Secretary to make a 0.4588% adjustment in 2018 instead of the adjustment that would otherwise apply under Section 7B2 to offset the prior recoupment adjustments. And that's exactly what the Secretary did. Plaintiffs, however, say that the Secretary was required to make an additional 0.7% adjustment, such that the total adjustment would have been 1.14588%. Now, as a threshold matter, their claim is precluded by the statute's review bar because they're challenging the amount of an adjustment. But whether it's a review bar question or just a merits question, the directive under the statute is clear, and the Secretary did exactly what the statute directed him to do. And I think if I may, I think it's important to keep in mind that Congress amended that subparagraph little Roman 3 to direct the 0.4588% adjustment after the Secretary had already announced that the total recoupment adjustment would be 3.9%. And so if Congress had wanted the Secretary to make an additional 0.7% adjustment to reflect that higher recoupment adjustment that the Secretary ended up making, then Congress would have said so. Instead of directing a 0.4588% adjustment in 2018, Congress would have told the Secretary to make a 1.1588% adjustment. There's no reason to think that Congress intended anything other than the 0.4588% adjustment that it specified in subparagraph little Roman 3.
Are we supposed to interpret the statutory language with the jurisdictional bar narrowly?
Well, I think there generally is a presumption in favor of judicial review, and so the provision should be interpreted with that backdrop. But I think here what the provision says is that it bars judicial review of any determination or adjustment under subsection 7B, and what the Secretary did was an adjustment under section 7B.
Did the Secretary call it an adjustment?
I believe so, but I confess, Your Honor, I'm not sure now what the language was in the rulemaking. The statute, however, refers to it as an adjustment. Little Roman 3 says, directs the Secretary to make an additional adjustment.
I guess the point I'm getting to is that, how are we supposed to know an adjustment when we see it? Is it like, the obscenity test? We'll know it when we see it? Or what are the characteristics of an adjustment?
Well, I think here the best...
Doesn't it matter if the Secretary calls it something else?
I think I think the best indicator here is the fact that the statute itself referred to it as an adjustment. And since we're interpreting the statute's review bar, I think it's very instructive to look at the way the statute referred to the thing that the Secretary did by increasing the standardized amount by 0.4588%. And the statute refers to that as an adjustment. And the statute more generally refers to what the Secretary otherwise would have done under 7B2 to offset the prior recoupment adjustments as an adjustment. So I think those are both very good clues and arguably dispositive here that what the Secretary did was make an adjustment.
Is there any codified language in the CFR that you're aware of? I'm looking at the preamble of that agency action, and it's expressly described as an adjustment in the preamble. They say they are finalizing the plus 0.4588 percentage point adjustment, but I don't have the actual reg or know if there's a reg, but this preamble tends to support you anyway, for what that's worth.
As does the statute, 7B, whatever,
right.
What is it, 1B? 7B 1B, capital B, says, which was the provision that was amended with the 0.45, says that you shall make an adjustment of the following amount. And both the statute and the preamble support that.
And again, Your Honor, Judge Wilkins, I think whether this is, as we've argued in our brief, we think this is within the plain terms of the review bar, but whether it becomes a review bar question or you decide to reach the merits, I think the directive under the statute was clear, and the Secretary did exactly what the statute directed him to do.
Under your provision, or your position, you don't even need the jurisdictional bar.
That's right. I think if you reach the merits, I think as the Secretary said in the rulemaking, the directive under the statute was clear. The statute directs the Secretary to make a 0.4588% adjustment, and that's exactly what the Secretary did.
The jurisdictional bar applies not only to judicial review, it also applies to administrative review. Was that invoked when the plaintiffs here challenged this?
I'm not sure, Your Honor. I think it was just expedited for immediate judicial review. I'm not sure if that issue was ever actually addressed in the administrative proceeding.
Okay.
Is the bar on judicial review jurisdictional in the sense that we have to address it first?
No, Your Honor. I think generally you do address it first. It's not a matter of Article 3 jurisdiction. And in the recent...
Ilka wouldn't compel us to... We could skip over...
you could, and that's in fact what this court recently did in the American Hospital Association case, which plaintiffs cited in their 28J letter. As to the hospital's second claim, the court expressed doubt that they could review it because they had just determined that the adjustment was within the scope of the review bar, but nonetheless assumed statutory jurisdiction, as they refer to it, to go on and address the merits and dismiss the claim on that basis. So, you could potentially do that if you wanted to.
But on the other hand, I mean, I had thought preclusion, judicial review, no review, jurisdiction strip, whatever you call it. I had thought it's actually an easier ground for you because the merits argument is that the secretary got this right. The reviewability argument is simply that the secretary was doing all of this under Section 7B, which seems very obvious.
Right. I agree, Your Honor. Yes. I'd be happy to answer any other questions if the court has any.
Any further questions? All right.
Thank you, Your Honor.
We'll give Ms. Pagonis 2 minutes for rebuttal.
Thank you so much. There we go. I am unmuted. First, responding quickly to a question that Judge Randolph posed concerning the administrative review in this action. The question of jurisdiction was the jurisdictional bar was raised in the issue statement before and the request for EJR before the PRRB. And the PRRB determined that it had jurisdiction and granted expedited judicial review for the federal courts to review, address the case. So it was not evoked by the PRRB. Now, I would just like to quickly point out that, for example, in Amgen versus Smith, where there was a question about a preclusion on review of the establishment of other adjustments, it was clear that we had an adjustment at play in Amgen, but the court said that the preclusion of review of other adjustments extends no further than the Secretary's authority to make them. And the same approach should dictate the construction of the preclusion statute here. The preclusion on review of adjustments should extend no further than the Secretary's authority to make adjustments. Now, under American Hospital Association versus Azar, that same analysis.
Gets back to Judge Katsas' question. I mean, that makes the bar totally worthless because the only time that you can invoke it is when the Secretary had authority to do what he did.
Well, the bar here operated for many years to wholly bar review of adjustments made in 2010 all the way through 2017, because in each stage, in each step, the Secretary had this authority to adopt an adjustment, applied his discretion to calculate the amount of the discretion and so forth, and adopted that adjustment. In 2018, Congress, if you summarize, what it says in B3, with it said to make a net negative 2.7412%. And instead, CMS adopted a net negative 3.4412% adjustment. CMS did something that was neither authorized nor contemplated by Congress, and Congress, far from authorizing the Secretary to make such an adjustment, said that the Secretary cannot make or cannot continue over an adjustment. This is extraordinary, unusual, and limited authority that's granted in the TMA with all the subsequent amendments that the Secretary does not have any place else in the Medicare Act. And that intent for a narrow authorization pervades the statute and makes clear that intent. And my clock disappeared, so I hope I have not impeded too far on your time.
Excuse me, judges, time has run out.
Thank you, Your Honors.
All right. If there are no further questions, we will take the matter under advisement. Thank you, counsel.
This honorable court is now adjourned until Thursday, September 10th at 9:30 a.m.
Goodbye.